Okay, hi everybody. As you heard, my name is Maki Iatridis, and I'm going to talk about what's new with environmental due diligence, and the focus is primarily on transactions, but there's always other related aspects to it. I'm going to break it out into 5 parts. But before I do that, since I am recording this and there's no audience here, which is unusual, especially for me, if you do have questions, you can email them to Kyle at the Boulder County Bar Association. He will send them to me and I'll provide an answer in writing, orally, maybe do a Zoom addendum, or I'm not sure how, it depends on the question, but there is an opportunity to ask questions and get some kind of an answer. So feel free to do that on your time. So the overview is going to be 5 parts. I'm going to give an introduction and some history. To me, understanding, it helps to better understand a change if you understand the history and where it came from. So I'm going to do that first. Then I'm going to talk about what is a phase one of the typical parts to it. Then I'll talk about what we're here to talk about, which is what's new, and then address some other stuff that you should be aware of and thinking about, and then close with some lessons to be learned, things to think about when you're going through something like this. So starting with the origins and history. So this phase 1 due diligence, most people say, hey, I want to buy some commercial property, let's do a phase 1. A lot of people really don't know where it came from, how it started. So the Superfund law, or CERCLA, is really the beginning. And that was enacted in 1980. It was not well written. It was in between 2 administrations, Carter and Reagan, and they were rushing to finish it. And CERCLA, as probably most of you know, is a strict liability statute, and simply by being an owner of contaminated property, you are liable under the environmental statute. And that didn't sit well with a lot of people, and it still doesn't sit well with a lot of people, but that is the law. So based on the initial uproar, in 1986, there was an amendment to CERCLA called SARA, and it created what's called an innocent landowner defense. And it also is known as all appropriate inquiry. So the idea is that for somebody looking to buy property, so not a current owner, but a prospective owner, that if they look to see if the property is contaminated, and you do a good job of it, so you do your due diligence, and that's where the all appropriate inquiry, so you're not just sticking your head in the sand, but you look at what you should be looking at, and at the end of it, you did not know and had no reason to know of a release on the property, then under CERCLA, you have an innocent landowner defense. So the idea is you look, you kick the tires, look under the hood, you don't find a problem, you buy the property, later you're about to excavate, you're about to put an addition and you excavate, you find a problem, and you get entangled in a suit, or you want to sue the previous owner. This is your defense. And it started in 1986. And so to do this, to perfect your defense, it created a whole cottage industry of phase 1 reports. And while the primary purpose under the letter was it's a defense to CERCLA liability, it really has become a standard of care in commercial real estate transactions. It's part of your due diligence to know what you're buying for business reasons, and not just for a defense. I mean, you'd want to know if a property is contaminated. Banks also want to see a phase 1 to make sure that their collateral is not impaired and that it can pay off a loan should it go south. It's also part of calculating a purchase price. You want to make sure that the thing has the value you think it does. And then phase one can also be relevant to doing a voluntary cleanup of what you find. So it has many purposes. And when you are about to do one, it is helpful, I think, to think about all your purposes and make sure that the work you are requesting will achieve the goals. So what is a phase one? It's an environmental site assessment, and there is a standard that ASTM, the organization, has developed, and they update it every 7 years, and that's why I'm doing this presentation, is that there's been a recent update as of November 2021, and that's what I'm going to talk about is what's new. And so typically the technical consultant will get this ASTM standard and follow it and then prepare a report. One of the things that a lot of practitioners don't think about is that it's really designed to be a defense to CERCLA liability. And if you were to read the standard, which is 60 pages long, single space, double columns, very fine print, you would see, if you did read it, that there are exclusions. And so when you order the work, you need to be aware of the exclusions and add exclusions into the scope of work if you need to. So the biggest exclusion I find that most people aren't aware is it doesn't calculate business risk. It doesn't talk about that. It doesn't look for asbestos, lead, indoor air, wetlands, historical issues, historical resources, and on and on. So really, it's important to tailor the scope of the phase one to the situation and the client's needs. So I always recommend, don't just say phase one, think about what it is the client wants. So after many years, there was another amendment to CERCLA after 1986, and in 2002, it's called the Brownfields Revitalization and Environmental Restoration Act. And it's also known as the Brownfields Amendments. And the reason that the prompt for this amendment was that a lot of people just didn't want to buy contaminated property. So the innocent landowner defense means you are innocent, so that you do your phase one, you don't see evidence of a release, you buy it and you find out later. But what happens to a deal where you do the phase one and it finds contamination or a release? Then you have contaminated property. The innocent landowner defense doesn't apply because you're not innocent, you know it's contaminated, and that would turn people away from buying contaminated properties. So to encourage the redevelopment of contaminated property, which is known as brownfields, and prevent the incentive to go develop green fields, the CERCLA was amended, and I have one person in the audience now. This is fantastic. This now is normal to me. Now I have someone to talk to. I'm just doing the background, which I think you probably know, for the innocent landowner defense. I just went over CERCLA, where it came from, and I was just talking now about the 2002 amendments. So I haven't gotten yet to what's new. Now I feel so much better. I'm not strange talking to a camera only. So in 2002, to prevent the development of green fields and promote the redevelopment of brownfields, CERCLA was amended and it added new defenses and revised the existing innocent purchaser defense. So it added a contiguous properties defense, which means if your neighbor is the source of contamination and the contamination migrates to your property, you have a defense to that. And then it added a very significant one, the Bonafide prospective purchaser defense, which means you do the phase one before you close, you identify contamination, and you decide you're going to buy it anyway. And unlike with the innocent purchaser defense, now you have a defense for what you do know is contaminated. One of the aspects of buying something you know has a problem is that it created a whole new affirmative duty to maintain the defense. So this is a post-acquisition duty of care. And it's distinguished from the pre-acquisition duty, which is what the innocent landowner defense provided. So before this amendment, you did your phase one, you saved it, it collected dust on the shelf. If a problem arises 10 years later, you blow off the dust and you go, here's my defense. But if you know it's contaminated, you have to take reasonable steps to stop continuing releases, to prevent any threatened future release, and then there's a whole bunch of other things you have to do, and those are known as the continuing obligations. The phase one then becomes a step in multiple steps to maintain your defense. So you no longer just let it sit and collect dust. So that was a big deal in 2002, and it still is a big deal, of course. So the Brownfields Amendments also clarified what all appropriate inquiries mean, meaning the phase one and due diligence. And as a result of this amendment, you now get a bit of more of a web of legal issues. And what I mean by that is there are several different ways you can define what all appropriate inquiry is. And so there are statutory criteria in CERCLA. There is the ASTM standard, which is a separate document. And then EPA was tasked with creating regulations. And it did after 2002 at 40 CFR Part 312. And to kind of, to try to avoid inconsistencies, the regs reference the ASTM standard, and they do so by date, because the ASTM standards get updated, as I mentioned, every 7 years. So if you looked at the regs today, it would reference the 2013 standard, not the 2021 standard that was published in November of 2021. So you've got different criteria. They're supposed to be seamless, but in practice they're not. And so one thing to be aware of, if you get into something very gnarly, you probably want to make sure that you've checked all your boxes and you're aware that there are different standards out there, and you should be aware of it. And this presentation doesn't really get into that topic, so it's really more of just a flagging of the issue. So under the statute, all appropriate inquiry, the main question to be answered, the big picture question is there evidence of a release? And the way it's done is that there should be an inquiry by what I call EP, the environmental professional. That's the geologist, environmental engineer, the person who's trained to do that. It's definitely not the lawyer. This professional is supposed to conduct interviews, past and present owners and operators, review historical records, any recorded environmental liens. They should look federal, state, and local records regarding hazardous substances, any permits issued to the property, for example. That professionals should go to the site, inspect it, look at neighboring property as well. The person should talk to owners and operators about their special knowledge of what's been happening at the property with regard to hazardous substances. And also look at the price. Does it look like a market value for clean property, or is somebody selling it for $10, which should raise a red flag that there's a problem like environmental contamination? So these are the statutory criteria to be looked at. So now when you turn to the regulation for all appropriate inquiry, the main question remains the same. Is there evidence of a release? But EPA interpreted the statute, and it made the inquiry more of a performance-based approach where the judgment of the professional is supposed to be applied. Some had advocated for a kind of a checklist approach, which to me is kind of like you were dumbing down the professional and not letting that professional think. And EPA said, no, it's not just about data gathering and then you put it together and you give it to a client. We want the professional to express opinions, give conclusions, and really address it. Pardon?
Stick his own neck in the noose.
Stick his own neck in the noose. Yes, I like that. That'll go on my next presentation slide. And as a lawyer, it also sticks your neck in the noose because you're supposed to, depending on what the client does, I mean, sometimes they come running to you and they've already hired the professional and they go, here's the phase one, it's final, what do you think? I get a lot of those calls. I always advise to anybody who cares to listen to me to hire someone like me, or at least the client hire a lawyer, a real estate lawyer, somebody who knows before you hire the environmental professional. So you can do scoping and make sure that it starts right and your odds of it finishing right are much higher. So the regulatory purpose, it went beyond just establishing CERCLA defenses. You can use the report for becoming eligible for a grant, because if you have a brownfields site with known contamination, you might want to get grant money to help clean it up. The grant also requires you to look for controlled substances, meaning a meth lab. So suddenly the hazardous substance definition of CERCLA, which is what you usually look for, has expanded. You're looking for more things. And we'll talk about later, we'll revisit this topic under the what's new category. And so the objectives were shifted from identifying recognized environmental conditions, or the acronym, there's tons of acronyms here, known as RECs, to identify conditions indicative of a release or a threat of release. So the reg is expanding the statute. And as to the performance standard, the judgment, the head in the noose, the neck in the noose, the professional is supposed to gather the info and evaluate the thoroughness and reliability of the data. So that is well past checklist approach. The professional should be telling you, I do have a good database, or I don't, or here are the data gaps. And this data gap, I really don't know what happened in these 20 years, and is this significant or not? Or there was a building on an aerial photo and now it's gone, and I have no one to tell me what it was used for. So a data gap can be significant or insignificant, and the professional is supposed to tell you. It helps you with risk management and the client making the decisions on what they want to do to go ahead to buy or not, or buy with a condition, that kind of thing. So if the professional says, hey, I looked, I really think we should do some more investigation, the professional is supposed to give that opinion. So again, EPA is making sure that noose is on nicely. Another issue that some practitioners don't appreciate, and it really can muck up the works, is timing. To get your defense, you have to do the phase one before closing. You can't do it afterwards. And what often happens is that environmental lawyers become deal killers because the timing of the phase one is left for the last minute. And then someone like me comes along and says, well, you got this issue, and if I were you, I would do X, Y, and Z, and it's probably going to take 6 weeks. And you go, wow, the closing is next week. And then things get messy potentially. The other timing issue is the shelf life of a phase one report. So people don't want to spend a few $1,000s to do another one when there was one just done a year ago. Or the seller did one and says, here you go, use mine. Well, to get the defense, it should not be older than 6 months. If it's older than 6 and less than 12 months, there's a way to update some sections. But again, some of these issues are not known. So those are two things that when you're getting into the practice and trying to, schedule things out and sequence things, you ought to be aware of these things. So now, coming back to one of my earlier points, the regulations cite the 2013 version of the ASTM. In November 21, you now have a new 2021 ASTM standard. EPA is going to review it, and then it will amend its regulation, and eventually it'll reference the 2021 standard, but it doesn't do that now. And so you've got what I call an interim period, and it raises, I think, a legal question of which one do you follow today, the 2013 or the 2021? And my answer to my clients is both. The phase one should, I recommend, say and make sure the consultant knows that it is to comply with both, because it's a standard of care, and the standard of care has now changed. So to me, the safer approach is belt and suspenders, and make sure that the contract with the phase one consultant, the professional, says your work will be consistent with both 2013 and 2021 ASTM standards. So now we've given the background and explained some legal uncertainty, and now I'm going to talk about the changes. What did the new phase one ASTM standard do? And you should be aware of. There's lots of things, so I'm just going to try to hit highlights and bigger picture issues. Overall, I think it added clarity and it prompts more thoughtfulness by the professional. In general, I think it's going to be more helpful, and there should be more consistency across phase ones. And yes, that's going to mean probably more transaction costs, more money to have the phase one prepared to begin with. People need to learn about it, and more to read, most likely. But hopefully, if you put more in the front end, it'll avoid those back end surprises that will be exponentially more expensive. That's why we do this stuff, preventive things. One of the main things it did is that it redefined some of the terms, like REC, and we'll get to that, and it created a new appendix, Appendix 4. And again, this is a 60-page ASTM standard, and I'm going to guess that most non-environmental lawyers have probably never even seen the document. But the appendix provides assistance on the rationale of when you make decisions. And this is where it goes to what I say, it prompts more thoughtfulness. And it gives a flow chart to help the decision making. So one of the changes to REC is that it really emphasized the notion of likely presence of a release. Because phase one is a paper study and a site walkthrough. There's no digging. There's no looking under things. So sometimes you see evidence that there were hazardous substances handled on the property for years. You don't see a big stain in the dirt, and you're not sure if it means that it's likely there or not. So this version puts more emphasis on likely presence, which I think consultants were downplaying before. It provides a definition of what likely means beyond the dictionary. And I'll give you an example. Just a month or two ago, a client gave me a phase one that was already done, so after the fact, not at the initial planning stages. And this was in a rural area, and it was a former gravel pit. And the report said that there's a pile of debris, looks like construction materials. It doesn't look harmful, and based on the aerials, it's been there probably like 15, 20 years. And the consultant concluded that this is not a wreck. I, in my notes to the client, said, I don't agree. I think when you've got a waste pile, the kinds of things that were at this property, to me, a waste pile is almost always a wreck. And I've even seen case law where someone said a waste pile is not a wreck, and later it turns out they were wrong. So the likely presence has been emphasized, and of course the consultant didn't know that there was a new ASTM standard. But that's the kind of thing that I often see. And so this is to help be more inclusive. Another definition was added, and it is called a controlled, recognized environmental condition. And what it means is that there's contamination that's known, and there are restrictions, such as contaminated groundwater, and the restriction is you cannot drill a well and use the water. And so the regulatory agency is happy with that. It's been documented, and now there's a phrase to use in the report, so that yes, it's a wreck, but we know it's under control, it's not going to hurt anybody, and the consultant should be using this kind of phrase, and it should not scare anybody because it's supposed to mean that it's been looked at and it's being managed appropriately. Whether it is or not, that's another issue, but there's now an expression for it. The other definition is called historical recognized environmental condition. And this means that we know there was contamination, it got fixed, and there's no restriction on the property, and the agency is happy. So this was in the prior version. The difference is the environmental professional is now directed to assess that the past closure meets current standards for unrestricted use. This is a big change. So let's say a property was cleaned up 20 years ago, the seller's going, hey, I know about X, it's taken care of, you shouldn't worry, here's the paperwork, the agency blessed it, you see a letter saying, sure enough, the agency blessed it, it's 20 years old, they're happy. And the twist is that the standards then should meet the standards today. So if the chemical is X and the standard has changed, the professional is supposed to tell you this. You need to know. Then what if there's a new contaminant that wasn't regulated 20 years ago but is today? We'll address that as well. So basically, this opens a significant issue. Another change is to the shelf life. Got more specific about when something within 6 months or 12 months can be used. You should pay attention to that. It changed the types of documents and made it more mandatory that need to be reviewed. And it also extended it to adjoining properties. So right now it is required that you look at aerial photos, fire insurance maps, local street directories, topo maps. Before it was discretionary. And now adjoining property means across a street or across an alley. So again, bigger scope. So now let's get to emerging contaminants. Some of you may have heard about PFAS, which were mostly in fire control chemicals. And these are known in the newspapers as forever chemicals because it is so hard to treat and they last forever. And they've been discovered in Colorado and all across the country, in many places in groundwater, and the feds have not established regs for PFAS. But the state has, and there's a typo there. Some states have. Colorado hasn't, but it's well on its way to doing that. So what does the consultant do? Do you look for them or not? So the new ASTM standard makes it clear that an emerging contaminant that's not yet regulated is out of scope because it's not within the federal definition of hazardous substances, which is what guides a lot of the scope. But what if your state does regulate it? The new standard says, well, you can add it within the scope and ask the consultant to look for that. So, how do you advise a client on this issue? Who wants to know? The buyer's interest in knowing could diverge significantly from the seller's interests in knowing. Let's say it gets added to the scope of work. Let's say there's a conclusion that you probably have PFAS here. Buyer goes away, scared away, and seller now has a phase 1 report in its hands with this conclusion. Some sellers don't want to see a copy of phase 1 reports. Anyway, I put question marks here. These are more pragmatic issues that need to be tackled, and really we can't do them here, but there's a lot of choices to be made here in the planning stage. Another change is that data gap was defined, which was the term used before. So again, it's prescribing what that really means. And it means that it affects the ability to identify a wreck. So again, giving more clarity to the situation. It requires maps and photos to be added, whereas before it was more discretionary, and major site features are supposed to be identified on these maps. Those are the primary changes, and I just want to look at my time here to make sure I'm still on track, and I think I am. There's a lot to that, of course, and if you really want to get into details, you should read it. Now we're into the section of this presentation which is other stuff, that I call, that you ought to think about, because it can be very helpful, and you also might miss some very important step. But ASTM has a bunch of other standards for this kind of environmental site assessment. We just talked about the phase 1. There is another one for phase 1s for rural and forested land. So by way of example, that gravel pit I mentioned earlier, that was in a rural area. It was a large parcel of property, and it creates different issues. Let's say somebody's buying land in the high country in January, and there's a lot of snow, and you can't see things, or you can't get to certain property, and you're wondering, is there mining out there, and is there acid mine drainage, or what, all sorts of things. It's not just your typical urban, suburban, commercial piece of property. Well, there's another ASTM standard, and it might be the one that the consultant should be using instead of the ASTM standard we just talked about. You might decide you want both to be satisfied and make sure that's in the consultant's scope of work and contract. So I just flagged that as something you ought to think about. There is an ASTM standard for continuing obligations. This is what I was talking to you about, continuing obligations on the Brownfields Amendments in 2002, where I said that if you wanted to buy contaminated property and you can't make it worse and what have you, well, there's a standard for that. So if you're hiring an environmental professional, there is contamination, your client says, yeah, let's go ahead and buy it. well, you ought to dust off this ASTM standard and make sure the consultant is complying with it and leaves behind an O&M plan on how to manage this issue, just like you would, for a building for asbestos or anything else. You want to leave in place a roadmap on how the user is to manage the property to not make it worse, do what they're supposed to do. And there are other reasons to do continuing obligation compliance, which is you may want to get a no action letter from the state, which your bank would like to see. Maybe you want to get covenants in place to restrict future liability. There's all sorts of reasons to do this sort of thing. I think this is one of the most overlooked areas that us lawyers could really add value for a client and help risk management and just be a good business decision for the client on how to manage property. Continuing obligations is not a duty to do the cleanup. It is just don't make it worse kind of thing. You have to cooperate with agencies, you need to comply with their information requests, and you need to be sure you give notices to those who reasonably should be getting notices. So let's take a quick look at some case law that my hope is that this will surprise you and get you to be more cautious and think about the implications of this in giving advice to a client. And typically, consultants won't know any of this stuff. So that's where your supervision of the consultant is very important. So what does reasonably available information mean? In order for you to get any of these defenses, you have to look at what's reasonably available. So there's this Wickland case where the innocent purchaser defense was not allowed because the court said the buyer should have known about problems from mining slag, even though the seller withheld the information. Obviously, maybe you have a claim against the seller, but in terms of that defense, you don't get the defense. According to this case, the info was available from the Regional Water Quality Control Board and from the buyer's environmental professional. So there's also a possible claim against the EP from the buyer. So that's where the contracts are super important. When you see an EP's contract that says its liability is limited to the amount you pay, you cross that out, and if they don't like that, I'd go hire somebody else. And certainly at least have liability coverage up to their insurance. In another case, Ashley, there was a fertilizer manufacturing activity on the property. Ashley bought it, contaminated it. Ashley was supposed to indemnify the seller, and Ashley, excuse me, that's giving me a reminder of something else. Ashley told the EPA, don't sue the seller, I'll take care of it. And instead, Ashley sued the prior owner to the seller, the one who put the contaminants into the ground, and we're suing for the cost to remove the debris pile, remove buildings, and it asserted the Bonafide purchaser defense. That's the Brownfields defense. They knew about contamination, but said, okay, I still am going to get my defense, and I'll get the guy who put it in the ground many years ago. Well, one of the elements of that defense is that you cannot have any affiliation with a other liable party. And the court interpreted this to mean that you cannot have a contract with the other liable party except to convey title. And you also have to meet your continuing obligations. And in this case, the court said the buyer failed the no affiliation test because it had a contractual indemnity to the seller and asked EPA to not sue the seller. I don't necessarily agree with this outcome, but my point and purpose is not to argue it. It's really just to flag it to show you how a lot of things that don't seem troublesome and should be innocuous may not be innocuous. And that's where you really need to understand the defense. If you are telling your client, yeah, you can have this defense, and this is how you do it. The court also held that the buyer failed the continuing obligations requirement because it exposed sums to rain. The rain put water into the contamination and spread it. You made the problem worse. And the buyer did not sample the pile and didn't cover it. So these are the kinds of continuing obligations you need to comply with to get your defense. And of course, the guy who got sued is going to argue, well, you made it worse. And then you get into a big cluster of who does what. Another ASTM standard that should be complied with is a phase 2. So phase 2 means sampling the dirt, looking at the groundwater, taking samples, sending them to the lab. And if usually that happens when the phase 1 says, yeah, there's some wrecks and I recommend investigation, well, there's a standard on how that should be done. And sometimes very much overlooked. Soil vapor intrusion. Some of you may have heard this. It basically means that whatever's in the groundwater or the soil is volatilizing, and like radon, it emanates through soil, comes inside the building, and contaminates indoor air quality. Often you can't smell it, you definitely can't see it, but it is a health risk in some cases. There is an ASTM standard to check on that as well. Another piece that a lot of people are unaware is that EPA has guidance for tenants, and it says basically that a tenant can get the owner defenses if the tenant, if you have, that's all the things that are like an owner. You have a triple net lease and various other criteria. Well, a tenant can get the benefits of owner protections, which again can be counterintuitive, but if you're doing a large lease and there's some contamination, well, maybe you do a phase 1 as part of your rental process, not just an acquisition. Anyway, it's all risk management. So lessons, this is the final part of the presentation. So my tips are, and of course, I have drank my own Kool-Aid and I'm a big believer in environmental lawyers. But typically I get calls when the phase 1 has already been ordered, already been done, and a red flag comes up. I almost never get a call that the phase 1 has not raised a red flag. And my thinking is, my advice is, that is something that should be sent out because you should see what a potential client missed. I'll give you an example. The phase 1 I've been talking about that I did a month or 2 ago on this gravel pit, well, the consultant went and read all sorts of records, public records, but it did not look at the Mined Land Reclamation Board's records. That is the state agency that issues permits for gravel pits. Has reclamation under the regs been done? Has the regulator blessed it? So the report said no problem, but it missed, in my opinion, a very important repository of information. And so if I only get the call saying everything, there's a problem and not the ones that say there's no problem, you could have that possibility of somebody who knows this stuff better than your average person flagging the mistake. Plan early. This is really more about risk management than about a circle of defense. I think it's just good transaction practice to be doing these things. The risk of not is that this can be a deal killer very quickly. And I encourage a team approach with the transaction attorney, client, consultants, to coordinate efficiently, to define the scope of work early on. The ASTM standard needs to be read as well as the regulation. Ideally, editing of draft reports should be done before finalized, and defining the scope of work, you need to talk to the client. What are they doing? What do they want out of it? What do they really care about? What don't they care about? And communicating all expectations. If you get to a situation where you find a problem, I always start with the exit strategy. Okay, it's a problem. What does one need to fix it? How do you get out of it? How clean is clean? Do not make assumptions on things. Don't assume that the consultant knows. Often consultants, these are $2,000, $3,000, $4,000 projects. They put the newest person on staff out there to draft it. Supposedly they get supervised, read by someone more senior. This is where some good legal oversight is important. And since we do have audience here, I can take a question in live.
I don't have a question, I have a comment. The people with smaller properties is going to have an unintended consequence. Because people with smaller properties and tenants are going to be pushed further away from doing this because it's now going to cost more to do it. So they're going to find excuses not to do it, whether you recommend it or not.
Yes, I agree with that. And I think there's also another built-in incentive that is as old as humans transacted business with each other, and that is the lowball bids. There will always be someone that's going to make it very attractive and inexpensive, and they're not going to know, most likely not going to know a lot of this stuff, and make mistakes, and the incentive, and then the person who really knows what's needed to do a good one is going to be higher priced. So even if the client chooses to do one, there's more incentive to have a bigger disparity in price, or the point you made, which is they just ain't going to do it. I agree with that. Yes, good comment. And you're a real estate practitioner, so what other comments, thoughts would you share for the audience?
I'd say you terrify me that the consultant doesn't know the what to do better than I do, because I'm not the environmental lawyer.
EPA did a study. They took a bunch of phase ones years ago, and then they took out the standards and they read them, and they found mistakes in over 90% of the phase ones that they surveyed.
They set out to do that, so that was a self-fulfilling
prophecy. They could have been right, and who knows whether there was little nitpicky things or big things. So anyway, for those who are watching this online later, you can email questions to Kyle at the Boulder County Bar Association, and he'll forward them to me, and I'll answer them, and maybe they'll add them as a Zoom addendum to whatever it is they do online. I'm not really sure. Anyway, thank you all for your attention, and have a good rest of your day or evening.